All rise. The Lawyer of the Apes is now in session. How's it going, everybody? Welcome to episode 13 of Lawyer of the Apes. Today, I just wanted to give everyone a brief update on the short squeeze MDL that is currently pending in Florida. Now, let's go back for a second and remember there are currently two complaints that were filed. One is the antitrust complaint, which is against Citadel, a bunch of other market makers, a bunch of brokers. And then we have the second complaint, which is a negligence action and some other actions as well against Robinhood. But there's also going to be a third complaint, and the court was given a status update in regards to that tranche of the complaints that are going to be filed. And that third complaint is going to be a federal securities action. So the court has issued a scheduling order that was agreed upon by the parties for how this is going to proceed. So the plaintiffs have to file their complaint by November 30th, which is about a month away. Then Robinhood will have until January 7th to file their motion to dismiss the complaint, which I'm sure they will file a motion to dismiss, as they did in all the other actions. Then the opposition papers will be due from the plaintiff on February 4th, and then the final reply brief will be due on February 18th. Now, that means that just for this section of the complaints, right, this third complaint, best case scenario we're looking at is having a decision on the motion to dismiss by, at best, March, the week of March 18th, for a decision on the motion to dismiss as to the federal securities part of the complaints. Now, this could also be modified, as we go along by maybe like a week or two if people ask for some extensions, but I wouldn't see more than that. So yeah, you're probably looking at early spring for a decision on this, but we already have filed and fully submitted the motion to dismiss on the antitrust aspect of the case, right? That was done a couple of weeks ago. We're still hoping, I was hoping to see it in the first couple of weeks in November, but now both sides, right? Both sides that already submitted their motions and opposition and reply papers, both sides have submitted additional authority to the court. So what does that mean? Well, at the end of the day, the judge probably already has started, reading the papers, maybe doing a little initial writing, for her decision. Perhaps her clerk is working on that. But now with this additional authority, she'll have to, the clerk and her will have to slow down a little bit and take a look at it. This is within their discretion. The judge doesn't have to look at this additional authority, but of course, they should, just so they have a complete record. So the defense side, originally, 2 days ago, the plaintiff was the only one who had submitted additional authority, but last night, defendant submitted additional authority as well. And this kind of surprised me because they submitted the SEC report, and I found this to be kind of odd for them to do. I didn't think the SEC report, has any type of actual legal support in it. It cites the news articles, and it's a really thin skeletal report. And again, for me, like when I had said initially, I thought that was the reason why it was that way, because I didn't want it to be used in court. And the defense is using it, but in reality, it's a worthless document. So it's really, I'm surprised they submitted it. But as a lawyer, since you're going to throw everything up against the wall and see what sticks. If that's what your rationale is, okay, fine, I get it. And you're allowed to do it. So basically the rule is in the court that a party can file a supplement when, through no fault of the party's own, certain relevant materials were not in the party's possession at the time that the party filed its motion, response, or reply. Now, for me, as a judge, I probably would look at it and say, well, is this really relevant material? Yes, it's relevant in the idea that it does discuss the short squeeze issue with GME, but it doesn't have any true substantive basis to it. And they said that the report was pertinent for two reasons. One, they say plaintiff's argument that government investigations are indicative of anti-competitive collusion, and specifically that it is indicative of collusion that the SEC is investigating the events concerning the January 28, 2021 trading restrictions. Yes, That's true, and that's why, again, I think I think the document shows that it's good that the SEC is investigating this to a certain extent. Even though the report was meaningless at the end of the day, it did show that there was some indication of collusion, and the report, again, whether it's favorable for the plaintiff side or the defense side, to me doesn't matter, because at the end of the day, again, the document is basically nothing. It doesn't say anything. You can't rely upon citations to the media, for any type of true substantive argument. It's not applicable in a legal filing. So the second thing they mention is, and this part was also interesting to me, defendant's argument that they're talking about their argument now, that the enforcement of plaintiff's claims would create a conflict between the Exchange Act and the Sherman Act, because SEC is currently investigating the 2021 short squeeze. See, this works against them, in my opinion, because they basically were showing the court that they're punting on this. They're not really going to decide this. They're just, for their concern is just about whether or not how this affected markets, like in a broad sense. And this is but not specific to whether or not there was any type of wrongdoing. I think they're leaving it in the court's hands, which makes complete sense. And I think it goes against defendant's argument that this would cause a conflict. I think the SEC is showing that this will not this is not going to cause a conflict, and we need the courts to make this decision. So I think this worked against the defendant. I was surprised that they uploaded it. So I'm not really sure, what their rationale was, but reasonable attorneys would disagree. So I'll be interested to see, if Alex takes a look at this, what he would think about it. Secondly, we have what the plaintiff uploaded. Now, this is a very interesting case. I'm not going to get into it in detail because I don't want the video to be 50 minutes long, but basically there's an action pending against Tether and a couple of other crypto companies, crypto exchanges, sorry guys. And basically this one says there was a wide-ranging conspiracy to artificially inflate the price of cryptocurrencies. The individual defendants were engaged in a scheme to make large, carefully timed purchases of crypto commodities using a fraudulently issued crypto asset called Tether, or USDT, in an effort to signal to the market that there was enormous organic demand for crypto commodities, thus causing the price of those commodities to spike and thereby creating sustaining a bubble in the crypto commodity market. Okay, I'm not getting into all the specifics about the background of the case. That's not really why it's important. What is important about it is that this court laid out a really strong comparison analysis to what we're dealing with Citadel and Robinhood in terms of violations of the Sherman Act and violations of and forming a conspiracy. This court, now let's remember something important. This case is filed in Florida. The MDL is filed in Florida. They're asking for California law to apply. So the two possible laws in that case are Florida and California. This case is a New York case. So the law, based upon what I read inside the decision here, seems very close to the Florida and the California law. And I'll be interested to see if the judge distinguishes this case on the law between New York, California, and Florida. But we'll see about that. But for now, if this case is heavily relied upon by the court, I think it will strongly impact the court's decision in denying the defendant's motion to dismiss. So let's go look at two quick parts. So in this case, the motion, they tried to move to dismiss the antitrust part of the case, and they said that, again, it's the same type of standard, right, that's set forth in Twombly. Private antitrust plaintiff must plausibly allege. You have to make a plausible allegation in your motion to dismiss. And in this case, the court said that the defendant did not meet their burden, and the plaintiffs did allege an antitrust injury, which means that the case can go forward. And I just want to read you guys a couple more highlighted parts. When consumers, because of a conspiracy, must pay prices that no longer reflect ordinary market conditions, they suffer injury of the type the antitrust laws were intended to prevent, and that flows from that which makes defendants' acts unlawful. So in this case, the prices were inflated. In our case, they took away the buy button and prices dropped. So it's definitely analogous to each other. So the cases are definitely in line with each other, not on all fours, but definitely in line with one another. And then I just want to jump ahead real quick to this section. Okay, this is the most important section, because this is really what we're dealing with in the case that's currently pending with the motion to dismiss. Plaintiffs adequately allege that defendants conspired to restrain trade in violation of the Sherman Act. That's exactly what we're dealing with. All defendants conspired to inflate crypto policies in violation of the Sherman Act, restrain trade affected by a contract, combination, or conspiracy. And they cited the Twombly in this case, which again, that's the leading case, right? That's the one we've gone over multiple times before. So here we go. The court concludes that plaintiffs plausibly allege that defendants engaged in an antitrust conspiracy. Plaintiffs allege the following allegations. So here they set forth all the allegations about why. This is basically what the judge would do in the Citadel and Robinhood case. They would set forth all the allegations, the communications that were made between the parties, et cetera, and so forth. Plaintiff also, and this part's great, common intent and common motive, to wit, the intent to stop the prices of crypto commodities from falling and to artificially increase prices. Each stood to profit significantly from the bubble in the crypto commodity market. Right, so they were saying, what was the motive? What was the connection between the two parties? That they were, well, they all stood to make a profit because of creating a bubble by keeping the price artificially inflated. Now, how is this analogous to the other situation? Well, again, we have gone over it before. Robinhood, Citadel, making money off of proof of PFOF. Boom. They couldn't kill the golden goose. Now that's really the crux of the argument. Defendants argue that plaintiffs failed to cite to communicate. This part, listen to this. Defendants argue that plaintiff failed to cite communications among defendants specifically regarding the conspiracy. However, they said no. In this case, the plaintiff cited to evidence of interfirm communications. Again, there was nothing very specific, and failure to quote specific communications is not fatal to the case. So the case law says you don't have to be very specific. You just have to allege that there were some type of communications. And that complaint shows that there were definitely communications between the parties that could potentially establish a conspiracy. Remember, you don't have to fully establish here. Plaintiffs plead equally plausible economic motives for defendants to engage in the scheme. All three groups were heavily invested in and completely dependent on the continued viability and growth of the crypto commodity market. Furthermore, defendants stood to profit by artificially inflating the value of their crypto commodity stores. Again, same thing here. We're dealing with a similar situation, very similar. And that's why they're relying upon this case, because it's very strong. As described above, plaintiffs' factual allegations plausibly give rise to the inference of an agreement between Digfinex and the exchange defendants, and at the motion at the motion to dismiss stage, plaintiffs must only put forth sufficient factual matter to plausibly suggest an inference of a conspiracy, even if the facts are susceptible to an equally likely interpretation. So here you go, guys. Remember, they were saying in their motion to dismiss, listen, we have a really rational explanation of what happened. This was not what everyone's making it out to be. Again, but at the motion to dismiss stage, the plaintiff only has to show a plausible suggestion and an inference, even if the facts are susceptible to an equally likely interpretation. So that means even if you take Citadel and Robinhood at their word, it cannot survive. It cannot defeat the complaint, and the motion to dismiss should be denied. And I think this is a really strong case. Now, this authority that the plaintiff uploaded was a very good idea. It was a very strong case that came out after they already had filed their opposition papers. And this was a great idea. Defense, not so sure about their SEC report argument. Think that's a big loser on their end. And the status report, at least we're moving along in the securities part. But I mean, I think the two main parts that are the most important are the Sherman Act, the antitrust part, and the negligence part. So that's what I have for this video, guys. I really appreciate all the support and everyone coming out to all the Twitter spaces. Do me a favor and hit the like button, subscribe to the channel if you enjoy the content, and please let your friends know. Remember, it doesn't matter if they're an AMC or GME or anything for that matter. If they're a retail investor, let's get people on the radar. Let's get everyone aware and up to date on what's going on, because this case does impact AMC and GME holders, but it also can impact anybody, right? We never know when something like this is going to happen, to what stock, on what day, and under what circumstances. So until the next video, the Lawyer of the Apes is adjourned.